Welcome back. This is part 4 of my analysis of the terms of the Google Books settlement. The slides for this presentation are available at my website, and an article accompanying this video will soon be available at ssrn.com. In the first part of this presentation, I introduced some of the basic terms of the settlement, and particularly focused on the structural features of the settlement, its treatment of orphan works, the creation of the registry, and the basic financial terms. In the second and third parts, I outlined the rights and permissions associated with particular works under the agreement. However, all of those rights and permissions depend fundamentally on the classification of a book. So in this final part 4, I go into the subject of book classification in detail and also discuss briefly some of the treatment of public domain works under the agreement. It should be apparent by this stage that the settlement contains a fairly complicated collection of default settings, modification provisions, and opt-out rights. For copyright owners who are actively managing their works, the most important provisions of the agreement will be those which allow them to customize how their works are used. However, the default settings embodied in the settlement are extremely important because to a large extent they control how the vast majority of works which are not being actively managed, the so-called orphan works discussed earlier, will be made available through the Google Books service. In short, the defaults matter because most authors are unlikely to take advantage of the numerous opt-out and opt-in provisions sprinkled throughout the agreement. It's important to note that some of the default provisions are subject to modification by the registry. However, usually the registry only has the option to make a work more available, not less. The settlement defaults may also be significant in setting the expectations of active rights holders as they define a new baseline or status quo for negotiation. A number of significant default provisions and customization opportunities have already been noted in the preceding analysis. What remains to be discussed is a detailed description of how books are initially classified. Google will initially classify all books as either commercially available or not commercially available as of the notice commencement date. This classification in turn determines, at least initially, whether a book is a no-display book or a display book. The agreement sets out the process for determining whether a book is commercially available in a significant level of detail. Essentially, to be commercially available, a book must be offered for sale new through one or more customary channels of trade in the United States. Google is required to make this commercial availability determination based on analysis of third-party databases and information publicly available from the Internet. The settlement recognizes that these sources of information may contain errors, and to the extent that information available from multiple sources is in conflict, Google is required to make its availability determination in a manner that is reasonably designed to minimize the overall error rate. The settlement also allows rights holders to provide information directly to Google that a book is commercially available. Google must act on this notification within 30 days unless it reasonably believes that the information is not accurate. A rights holder can also notify Google through the registry of any mistaken classification. When no information is available from these sources, the book will be classified by default as not commercially available. This same initial determination of whether or not a book is commercially available will be used to initially classify books as either in print or out of print, a classification which can then be altered by the terms of the author-publisher procedures. Regardless of commercial availability, a book will be considered to be in print under the author-publisher procedures as determined by the terms of the relevant author-publisher contract, or if the publisher announces its intention to publish a new or existing edition within the next 12 months. If neither of these tests is satisfied, a book is classified as out of print. In-print books that cease to be commercially available will be reclassified as out of print. If the registry reclassifies a book as out of print, it will direct Google to change the book's classification to a display book. However, if the registry reclassifies a book as in print, the registry will direct Google to change the classification of the book to a no display book only upon the express request of the rights holder of the book. These classifications, commercial availability, in print and out of print, are only the starting point. Regardless of the initial classification, an individual rights holder or the registry can change a book's classification, thus affecting the rights and permissions associated with that book. Either the registry or an individual rights holder can change the classification of a book from no display to display, but only the rights holder can change the classification in the other direction, or exclude a book or part of a book from some or all of the display uses, some or all of the revenue models, or the book annotation sharing feature. Finally, it's important to say something about the public domain. Under US copyright law, a work will become part of the public domain when the term of copyright protection expires, or if the work is made by the US government, or if the work is expressly dedicated to the public domain. In addition, in the past, it was possible for works to become part of the public domain because they were published without the appropriate copyright notice, or because the copyright owner failed to renew his or her registration. Although these formalities are no longer a part of US copyright law in the present day, they still affect the copyright status of works published in the past. The settlement contains a safe harbor for Google with respect to books it mistakenly classifies as public domain. To take advantage of the safe harbor, Google must follow a specific process for determining whether a book is in the public domain. The process is not mandatory, but it must be followed for the safe harbor to take effect. The extraordinary length of copyright protection and the extraordinary legal and factual complexity of determining whether a book is in the public domain significantly diminishes the usefulness of what should be a rich cultural resource. One of the anticipated benefits of the settlement agreement is that it creates strong incentives for Google and the registry to correctly identify which works are in the public domain. Once identified, that knowledge becomes an important resource for all of us. This is the end of my review of the terms of the Google Book Settlement Agreement. In the first series of videos, I reviewed Google's fair use argument and analyzed the likely result of the copyright lawsuit, which the settlement probably renders unnecessary. In the final series of videos, I will compare the settlement and its terms and effect to the outcome of that court case that never eventuated in order to make the direct counterfactual comparison.